Welcome to the Scottsdale Planning Commission public hearing. The city encourages your interest and participation in the hearing process. The Planning Commission is an advisory board to the City Council on land use and zoning matters. The meeting agenda items are development applications that require public hearings. The Planning Commission considers the request and makes a recommendation for approval or denial to the City Council. The City Council makes a final decision for or against approval of the application. The agenda consists of the roll call, minutes approval of the prior meeting. Continuances are for items that will not be heard tonight. Withdrawals are for items that have been withdrawn from any further consideration. Consent agenda is for items not likely to require a presentation or discussion. All items on the consent agenda may be voted on together, and any commissioner may move any item from the consent agenda to the regular agenda. Regular agenda is where each item includes a presentation and recommendation by staff, a presentation by the applicant, and public testimony. After, the applicant will have the opportunity to respond to public testimony. The Planning Commission then discusses the case and votes. Non-action is for items for discussion, and no vote will be made by the Planning Commission. Citizens wishing to speak on any agenda item may fill out a blue speaker card, or if not willing to speak, may fill out a yellow comment card and turn it into the staff table before the agenda item is to be discussed. The chair will call you by name when it is your turn to speak. When called, come to the podium, state your name and address, and then begin speaking. Groups wishing to speak should elect a spokesperson to represent the views of the group. To facilitate the meeting, your comment will be limited to 3 minutes for individual speakers, 1 additional minute for each additional individual present at the meeting who has contributed their time to a representative speaker, up to 10 minutes. Please format your speech to be accommodated within the applicable time frame given. For convenience in timing presentations, a light system is installed on the podium. The light will be green for 2 minutes and yellow for 1 minute. Please conclude your comments when the red light appears. Thank you for your time. Now we'll begin with the roll call.
Chair Higgs.
Present.
Vice Chair Young.
Here.
Commissioner Gonzalez.
Present.
Commissioner Kaminsky.
Here.
Commissioner Ertel.
Here.
Commissioner Scarborough.
Here.
Commissioner Serena.
Here.
All present. Thank you.
Thank you. Moving on to public comment for non-agendized items. That would be the yellow card. It looks like we have one. Is that a request to speak? I'm sorry? Yeah, non-agenda items, but I don't know if they can speak if they want to. No, they're just written. Okay. Okay, thank you. We've received 2 yellow cards, thank you. Now we'll move on to the administrative report. Mr. Curtis.
Thank you, Madam Chair, members of the Commission. I just wanted to bring to your attention, as always, the agenda order is determined chronologically. When we get the agenda items or when we get these cases, usually the ones that have been in our office end up being on the agenda first. So that's typically how we set the order. Tonight we have 2 items on the regular agenda. Both are text amendments. And so the Commission, this just reminded the Commission, has the ability to reorder those if they want. And if we're anticipating maybe less of a conversation regarding item number 3 regarding the IGC implementation text amendment, you can move that to be heard first if you think that there's going to be some, and get that out of the way if you think there's going to be more dialogue regarding the care homes text amendment that's in front of you. So I just wanted to remind you that you definitely have the ability to change the order of the agenda items if you so choose, depending on the sentiment of the board, or the Commission, excuse me. And then I wanted to draw your attention that regarding the current item number 2, regarding the care homes text amendment, there's some comments that we had received, and we had thought that they were included in a link into the report, but it turns out that it wasn't. And so there are 4 comments here, but if you notice that they're all identical in terms of the format and what the comments are. So we just have to apologize to the people that submitted this as well as the commission, that for some reason it wasn't linking in the digital packet that we provided to you. So just wanted to bring your attention to that. And then lastly, we do plan on meeting on May 10th, our next meeting. That's all I have for tonight. Thank you.
Thank you, Mr. Curtis. It does appear that we will have some, definitely have some conversation around the care homes tax amendment, given the feedback from the community. However, I'm not sure how to best gauge the fellow commissioners' interest in moving, flipping the agenda items from, so that number 3 is before number 2. I don't know how to gauge the length of conversation that may come about. Suggestions on how to get everyone's feedback?
I'm fine just leaving it as is.
Okay.
I'd leave it as is.
Okay. Okay. So with that, we will move on to agenda item number 2, 1TA 2022 Care Homes Tax Amendment. Mr. Bloomberg. Apologies. We did not do the approval. Why do I skip over that? And I see Bill giving me, Commissioner Scarborough giving me that look. Can I get an approval for the regular meeting minutes from March 8th?
So move.
I'll second.
Okay, we have a motion from Commissioner Ortel and a second from Vice Chair Young. Roll call vote, please.
Chair Higgs,
Yes.
Vice Chair Young,
Yes.
Commissioner Gonzalez,
Yes.
Commissioner Kaminsky,
Yes.
Commissioner Ertel,
Yes.
Commissioner Scarborough,
Yes.
Commissioner Serena.
Yes.
Motion carries 7-0. Thank you.
Thank you. Sorry about that, Mr. Bloomberg.
No problem. Thank you, Chair Higgs, Commissioners. Greg Bloomberg, here to give you a brief presentation on 1TA 2022, the Care Homes Text Amendment. This is a citywide amendment to the Care Homes Ordinance. So I'll give you a breakdown of what the request entails. The intent of this amendment is to amend the definition of care home, also amend the criteria for obtaining a disability accommodation associated with a care home, add criteria to the ordinance for requesting a minor disability accommodation, and I'll get into what those are in just a moment. There are no changes proposed to the care home criteria, for example, separation, capacity, floor area ratio. None of that is proposed to change with this amendment. Additionally, a lot of the oversight that was incorporated into the last text amendment in 2017 is being maintained. For example, they have to get whether it's a care home or a so-called sober home, they have to get a state license and undergo an annual fire inspection. So there is still oversight as a result of this text amendment. None of that is changing. That's not going away. And we have received some public comment. I know we have some folks here that are going to speak on that. So I'll just briefly go through the proposed care home definition. Basically, a care home shall mean any licensed home pursuant to Title 36 of the Arizona Revised Statutes, shared as a primary residence by more than 6, and that's key, and I'll get into that in just a minute, but no more than 10 persons, and in which on-site supervisory or other care services are provided for disabled residents. So really quick, let me just go through what a disability accommodation is all about. What is a disability accommodation? It basically is an option for a person with a disability or someone who represents someone with a disability to request relief from a development standard or from a care home criterion. So the minor disability accommodation is a request of 10% or less of a development standard. So for example, if a person with a disability wished to locate in a home, right now the separation requirement is 1,200 feet between care homes. If a person found a home that was, say, 1,120 feet from another care home, that's less than 10%. That could be processed administratively through the zoning administrator. A standard disability accommodation greater than 10% of a development standard or criterion. I'm getting ahead of myself here a little bit. So that's what those two distinguishing, the baseline or the cutoff is 10% of the development standard or criterion. So I got ahead of myself. So the minor disability accommodation is processed administratively through the zoning administrator, and standard disability accommodation requires Board of Adjustment approval. So timeline, we went to the Neighborhood Advisory Commission on February 23rd of 22. We had 2 open houses, both of them are in June. We're here before you tonight for the Planning Commission consideration, and City Council was tentative. A couple of things I wanted to talk about real quick that it's not part of my presentation. One of the reasons there was such a pause between the open houses and this hearing, you know, it's been almost a year. We had some feedback from the community that we wanted to address and also provide opportunity for some additional feedback from the community, should there be any. And we also had some challenges, some comments from the community that resulted in us receiving word from the Justice Department that they were going to investigate this. And to my knowledge, that's still open, that investigation. I don't know where it's at. Maybe, I don't know if Joe can, or legal can clarify on that. But that's the main reason there's been such a long pause on this. I haven't heard anything else from any other members of the community other than the providers and the folks that attended the open house. So I just want to make sure that that was clear. And then I mentioned the 6, I'll go back to that slide real quick. So one of the key things about this amendment is that if a care home, even if the care home is licensed, if there's 6 or less, our definition of family is 6 people living in a home. If there's 6 people or less, regardless of whether it's a licensed care home or not, that's a single family residence. They will still be subject to oversights, as we mentioned, but they will not be subject to any kind of zoning criteria, any separation or anything like that. So that's the gist of this change to the definition of the care home, is to clarify that anything less than 6 is a single family residence, and it will not be subject to zoning criteria, and it won't be mapped or anything like that. So I wanted to clarify that as well. And that concludes my presentation. We're all available here at the table for questions, and I know we have someone here who wishes to speak on that.
Thank you, Mr. Bloomberg. Before we move to the public comment, are there any questions from the commissioners?
I have one. I wanted to comments first, but just one question to clarify. You lined through in the packet on stuff that you were changing, but now this less than 6, that's just a new add. We're not removing it. Previously, it was just the no more than 10, and then it's, help me out with that. Like what's that less than 6? What's changed there? What was that language prior?
Chair Higgs and Commissioner Serena, nothing's really changed. That's the thing about this amendment. All we're trying to do is memorialize something that we've been doing already, and that is, if it's a care home with less than 6 residents, or 6 residents or less, we're not going to do any kind of zoning tracking or anything like that. We've been doing that now for, I believe, a couple of years now. So nothing's really changing process-wise. We're just updating the definition to memorialize what we've already been doing.
So can you bring that text back up again? I just want to make sure, since we're talking about changing the text, that I fully understand what we're changing. So shared by primary, so before that, that more than 6 but was just not there at all, and it just read shared as primary residence by no more than 10.
And I should have clarified that. My apologies. Yeah, the orange text in this definition is brand new text, and then there's strike-throughs to clarify that.
Is that orange or yellow?
I think it's orange.
It's more of a yellow.
It looks orange on my
Can
screen.
we vote on that, Joe, at the end of the night? Okay, so that's it. No. Okay, all right, I'll hear the comments. Thank you. It's yellow.
Commissioner Tell.
Oh, thank you, Chair. The comments that we received dated April 7th, Estelle Wallace and Ms. Seaweck, you had mentioned that, I'm getting ahead of myself too, just like you did. You said that you that you took the 10 months to get to where we are tonight because you were working on comments that had been made at open houses or, whatever, earlier. These comments that came from Ms. Seewick and Wallace, you've looked at those, I suppose. You know,
Correct.
Were these comments similar to what you had received at the open house and addressed comments like these in that, or are these additional comments that were outside of the scope of what had been provided at the open houses?
Chair Higgs and Commissioner Ertel, they're very similar, and I know that Ms. Dukes, Heather Dukes, is going to speak to you about this, but a lot of the comments that you received from those providers were brought up at the open houses. So it's not like there's new information, but they're recent comments.
Have you bounced this off of any of those people who had commented at the open houses and so forth to, see what their reaction is to the changes?
Well, Chair Higgs and Commissioner Ertel, most of the comments that I've received were from providers. And I know Ms. Dukes represents a few of the providers that are here, a couple of the providers that are here tonight, and she also is representing a few other ones that I believe. And so most of the comments I've received have been from those providers.
Okay, thank you.
Commissioner Kaminsky?
Yes, I was wondering if you could explain the nuance of the difference between multifamily and single-family. There was a comment here that this would somehow prohibit care homes in a multifamily zoning.
Chair Higgs, Commissioner Kaminsky, that's actually correct. Right now, care homes, licensed care homes are only permitted in single-family zoning. Now, there's another category called group homes, which is a group living scenario. Those are not allowed in single-family zoning. They're only allowed in multifamily zoning. Single-family is a single-family detached community. Multifamily could be apartments or condos or something like that.
Okay, so there is accommodation, it just has a different definition under group home for that zoning classification.
Commissioner Kaminsky, correct.
Thank you.
Vice Chair Young?
Thanks, Chair. Mr. Bloomberg, thank you for your time yesterday. You answered a lot of my questions, Mr. Curtis and Mr. Padilla. You had said that any care home that is 6 or less will not be mapped. Is there any provision if, say, 2 care homes open next to each other with 6 occupants to somehow trigger a mapping?
Chair Higgs, Commissioner Young, no, that's not the objective of this amendment. If it's 6 or less, it's just going to be a single-family residence, and so it wouldn't be mapped. It wouldn't trigger any kind of zoning requirement.
Okay, so there could be 6 of these in a row with 6 or less occupants.
Feasibly, correct.
Okay.
Commissioner Gonzalez?
Yes, sir. One of the things I had, and maybe this is maybe not within the difference preview of planning, but it is somewhat of zoning as far as on the fire side of this. I know the fire marshal has had a little bit of trouble when they do some of the interviews on the care facilities, in that there's a definition between certain disabilities as far as somebody being able to take care of themselves and somebody who was let's say what we call bedridden, or they're not able to facilitate everything by themselves. Is there a provision in this at all to address any kind of fire hazards or any kind of description? Because I know, although it's still residential zoning, there is provisions within the fire marshal has that he has to take in certain aspects of the people's ability to exit the fire areas.
Chair Higgs and Commissioner Gonzalez, there was a provision that I believe is proposed to be stricken that requires, compliance with building and fire codes. And the reason why is because the building official can make their own determination on a building code violation without the help of the ordinance. Very similar with the fire marshal. The fire marshal could make a determination that, for example, the occupancy is way too high. You've got too many people here when they do their fire inspection. So we're leaving that to the building official and to the fire marshal. So that's what I was talking about when I talked about oversight. That's still in place. That's not changing.
Very good, thank you. I just wanted to get that clarified because I wasn't quite sure exactly how that would impact things.
Sure.
But, that's definitely something as far as safety is first in mind as far as that type of zoning is concerned. Thank you, sir.
Okay. With that, I think we will move on to the public comment. Ms. Heather Dukes. As a reminder, you have 3 minutes to speak, and if you could first please state your name and address. Thank you.
Good evening, Chairwoman Higgs and members of the Commission. My name is Heather Dukes, and I'm an attorney having an address of 5527 North 25th Street in Phoenix. I'm here this evening on behalf of sober living home operators and disabled residents who oppose this care home text amendment. We have submitted several letters in opposition, and those have been attached to the staff report you received in advance of tonight's hearing, and we also submitted some during the public comment process. Rather than to reiterate each point in those letters, I want to provide some history for your consideration. This text amendment is before you for one reason. My client, Scottsdale Recovery Center, won a Scottsdale Board of Adjustment case in November of 2021, which found that a sober living home was not a care home. That was the board's formal ruling. The board also found that the zoning administrator interpreted sober living homes. When he did that, when he made sure that it was a care home with his interpretation, that interpretation was, and I quote, arbitrary, capricious, and an abuse of discretion. The board also found that the sober living home use was not a care home because there was no health care institution license and no on-site supervisory or other care services being performed in the home. After we won that decision, no appeals were filed in court and it became final. But surprisingly, after that final decision, when other sober living home operators came to the city to file an application for a new location, the city continued to characterize them as care homes after we'd already gotten that decision from the Board of Adjustment. This resulted in my clients filing a HUD complaint against the City of Scottsdale based in part upon the city's discrimination in its zoning ordinance, but also the discriminatory treatment when these operators came in to file their application. And what's interesting is this: after the city received our HUD complaint and a list of discriminatory provisions in the zoning ordinance, we gave them a list, the city moved forward with this text amendment, and they did not address any of the discriminatory provisions. Each one of the sections in the letter were given to them in advance after the HUD complaint. They still haven't been addressed in this text amendment before you. In fact, we believe that it increases discrimination. It attempts to broaden the definition of care home to include sober living homes, and it also imposes new requirements for disability accommodation requests that are very minor, such as notifying the neighbors and then having a public comment period when before that wasn't required. None of the major issues within the zoning ordinance have been addressed by this proposed text amendment, and if you look at the staff report, we've given the reasons, the reasons for the discrimination. It's in a letter dated June 16th, 2022, an email dated September 16th, 2021, and an email dated December 5th, 2017. So to conclude, I would ask this Planning Commission to either recommend a denial of the text amendment as drafted or continue this matter so that staff can continue to work with the City Attorney's Office to address some of these concerns. And if you have any questions, I'd be happy to answer them at this time. In particular, if you'd like me to answer any questions regarding the multifamily zoning district or the definition, I'd be happy to answer them from our perspective. Thank you.
Are there any questions from commissioners for Ms. Dukes? Commissioner Serena.
Yeah, I was on the commission when we did this last time, and so I'm trying to reach back into my memory, but we've had a lot since then. So you're representing the care home, not the sober association, right? Is that correct?
I represent several sober living home operators. I do not represent at this time the Arizona Recovery Housing Association.
Not the recovery housing.
Yeah, just individual operators.
Okay. And the sober living homes, just tighten up, and I appreciate the 3 minutes you gave, but your contention is that the city is attempting to update this to make it less inclusive of sober living homes?
Correct. And the issues that were raised during the Board of Adjustment hearing, part of the reason why they ruled in our favor, it goes back to the fact that care homes, if a sober living is considered a care home, and that's what this new definition attempts to do, care homes are not allowed in the multifamily residential zoning district. They're not in there at all as one of the permitted uses as of right. Now, a group home, a care home and a group home are two different things. You can't be one and the same. A group home has no care, no licensing by the state. And so if a sober living home has 10 people, let's say, or let's say it has 7 people, and they wanted to live in a condominium in a multifamily residential district, and it's a big condominium, and there's enough space for the residents, they would not be allowed to do that. And that in itself is discriminatory. This has been submitted several times to the city, but there's a joint report, a joint statement that was issued by the Department of Housing and the the Department of Justice and the Department of Housing and Urban Development. And they have a specific section in here where it talks about local zoning and land use laws that treat groups of unrelated persons with disabilities less favorably than similar groups of unrelated persons without disabilities violate the Fair Housing Act. And that's what's happening between the care home and the group home. You've got homes of unrelated individuals living together in an apartment. They can live in a multifamily condominium apartment, no problem. But the minute you put in someone with a disability, that's considered a care home, now you can't live in a condominium or an apartment.
Okay. And I don't want to live on this more than 6 but not issue. What's your contention on why that was added to the language, or do you have opposition to that piece of that, or no?
No, I think, and I can talk with Michelle, but the clarification that more than 6 is required to be a care home, the definition of family says, I think, 6 or less?
Right.
Yeah. So when you have that few people, it doesn't matter whether you have disabilities or you're providing care, it's all just considered a family, and they're living as a family unit. And that's a good change, is that when there's less, if there's 6 or less, it's considered a family no matter whether you're licensed or not.
Okay. All right.
Commissioner Kaminsky.
So in a situation in a multifamily development, apartment or condo, 3 bedrooms, you could have 6 individuals living there, no issue. So there is a provision to allow them, not even as a group home, but as a single-family unit within a multifamily development.
Right, but when you get into that 7 to 10,
Right.
then you can't. That's when the discrimination occurs.
Right, but I guess I would look at the occupancy of how many people do you want to fit. In the multifamily developments usually have 1 to 3 bedrooms typically. So I think if they want more than 1 unit, they could have 2 condominiums with 6 people in each.
But yet if you had a group home with 7 to 10 people, you wouldn't make that distinction? They would be allowed to live in a 1 to 3 bedroom condominium?
Whatever the occupancy requirements are and the requirements for that.
That's what I'm saying, though. Then you should add care home to multifamily residential districts and allow the occupancy requirements to be applied across the board to both group homes and care homes. Because the only distinguishing factor you're making is that they're disabled.
Where does it say disabled? Any licensed home?
So the licensed home, they've changed it from, it's anything that's providing care. So if it's a behavioral health residential facility, a sober living home now, all of that's grouped under this care home definition. And sober living homes, by their nature, are providing care to sober individuals that are considered disabled under the ADA and FHA. Behavioral health residential facilities treat not only people in addiction recovery, but also mental health issues, behavioral health issues, and so those individuals are disabled as well. They could have Alzheimer's, it could be, any type of dementia. Those are all disabilities. But with the group homes, because there's no care being provided to these individuals and it's not licensed by the state, that's where the disability issue comes into play.
Commissioner Gonzalez, did you have something?
Well, I'd like Mr. Padilla to kind of weigh in a little bit on this, because he understands the details a little bit better than some of us lay people.
Both I and Mr. Anderson have worked on this. He's going to go ahead and weigh in. Both Mr. Anderson and I have worked on this. He's going to go ahead and weigh in.
Chair Higgs, Commissioner Gonzalez, one of the things I think that's important to keep in mind is the entire process is all subject to further reasonable accommodation requests. So, for example, the example that Ms. Dukes has offered you as the 7 people in a condominium union, it may not meet the predetermined exemption of the care home as it is, but her clients can still come to the city and, excuse me, and explain why the resulting would be discriminatory, and that would go to the Board of Adjustment, and the Board of Adjustment would have an opportunity to determine that if, in fact, yes, this, as it is applied in this particular circumstance, results in a discrimination, the Board of Adjustment would have the ability to grant that reasonable accommodation. So it doesn't foreclose. The care home definition in and of itself is kind of a predetermined reasonable accommodation by the city. If you look at it from the standpoint of normally a single housekeeping unit is 6 or less, the care home is allowing 10, so right there you're getting an additional 4 plus on-site supervisors just by virtue of the face of the statute. But that does not foreclose further reasonable accommodation requests, and that's pretty clear in the code, and that her clients can still come to the city and explain why in this situation I'm using this property, or desire to use this property, and your ordinance prevents it, and therefore there should be an accommodation, and the city is instituting a process for that, has a process for that she can use. So.
If I may respond for just a second, that applies. A reasonable accommodation is a process that people with disabilities get to utilize when it's a facially neutral law, meaning like if there's a setback requirement that applies to every single residence in a single-family residential zoning district, and for some reason that person with a disability needs to come in and say, you know, I really need my building to encroach into this setback because it provides me additional room for my wheelchair. That's an example of a facially neutral law, right? It's a setback that applies to everyone. What we're talking about here is discriminatory on its face. You're not allowing care homes in a multifamily residential district on its face. You shouldn't require people with disabilities to come in here and have to go through an entire application process, having to notify their neighbors, having to be subject to that. Each time that Michelle has come before the Board of Adjustment, and it's been twice now, it's traumatizing. It's stressful. You've got angry, upset neighbors, and why should they be required to file an application just to be treated the same way with everyone else? So again, the disability accommodation process is there when the laws are facially neutral. That's not what we're dealing with here.
I don't have any more questions for the speaker, so I don't know if anybody else wants. I don't want to just make you stand there the whole time. It's
No.
not litigation, so if anybody else has any other questions, I have questions for staff. Help me out on the change of dwelling, the thought on our change from dwelling to Title 36. Obviously, dwelling is somewhat vague, and Title 36 of the Arizona Revised Statute seems pretty specific. Can someone elaborate on why that was made? And can you, without reading all of Title 36, tell me what is Title 36? And
Chair Higgs, Commissioner Serena, the proceeding that Ms. Dukes referenced in her earlier public testimony, one of the issues that was involved was that the sober living homes that are regulated by the state, that regulation, it didn't exist in 2017 when the city first adopted the most recent the code amendments. So post 2017, the state has adopted a statutory scheme for sober living homes in particular. A dispute arose because the area of Chapter 36 of the state was not the healthcare, healthcare institutions chapter under the statute. So that right there is basically just to clarify that the sober living homes, although under Chapter 36, but not under the healthcare institutions, would be eligible to be a care home, thereby giving them the extra number of people potential that wouldn't have otherwise. So it's actually, like I said, it's a predetermined reasonable accommodation for them. I'll also point out that, it's not, we disagree that it's not facially neutral. It's not targeted at disabled people. It's actually there to provide an accommodation, so.
Well, I don't see the disagreement. This whole situation is just so crystal clear. That's a joke. It's not crystal clear at all. I personally, and I want to hear more discussion from the commission. I'll tell you just where I'm coming from immediately is I would, changing a text amendment like this, I remember how controversial it was when it happened last time, and that was before the timeline of Title 36 and what's being discussed. I'm probably going to need a lot more time to try to digest this, because this goes into a level, you're talking about DOJ suits and what have you. So, my initial reaction is I would probably want to spend more time with a continuance on this to really grasp exactly what I'm supporting or not supporting on this text amendment, because just this 10 minutes we've been talking, or 15 minutes now, has created a lot more questions. It's not just as clear as reading through this. I do have one question for staff. In the packet, you wrote one of the questions, bullet point questions, does the city know how many care homes there are? The answer was the city tracks care homes by mapping them, but does not keep a running total. I mean, so I understand the mapping piece, but is there just so many that we don't have anybody on staff that can count that many? Like, can't we just look at the map and just count how many care homes are on the map?
Chair Higgs and Commissioner Serena, I think that it's a picture in time. There are a lot of variables. So the map contains, again, the variables. There are some licensed homes that exist. There are some previously licensed homes that no longer exist. There are some providers that ask the city, because of the separation requirements, to map their proposed facility so they could secure it while they move forward in getting all of their licensing from the state. Sometimes those are homes that are under construction. Sometimes those are homes that are being remodeled to accommodate that. So then there's a placeholder of a home, but it's still not licensed. So the reason why that answer was given, because there are variables in a picture in time of what degree it is a valid home, depending on what you consider valid. And it could be, again, just a care home location that's not quite licensed yet versus one that's been licensed for years and is operating. And again, from one day to the next, care home provider can close down and then they sell it to another single-family operator. But with your permission, Chair Higgs, I'd like to expand on something that the speaker mentioned about multifamily districts. The scope of this text amendment doesn't reach into different districts and allowing different land uses in different districts. That would be a different scope, a whole different text amendment, almost like what Commissioner Serena remembers in 2017 or whenever we did that last one. This text amendment is pretty narrow. It maintains the existing zoning that they're allowed. It clarifies the number based off the family definition. To make that easier, like Commissioner Kaminsky said, in multifamily, if you have fewer than 6, then if you're licensed or not, that's all right. And this text amendment deals with those, expands some of the provisions with regard to the disability accommodation and simplifies some of the disability accommodation criteria by striking some of those out. But that's how narrow this text amendment is. It doesn't get into, well, what about this other zoning district and what about this other zoning district? So I just wanted to make sure that that's clear. Now, there may be a desire in the future if the community gets together and wants the care home provisions in other zoning districts, but that would be a separate text amendment, separate outreach, separate impacts and consequences That's not what this has, and I think the speaker was hoping that the scope would expand into other zoning districts, but that's not what's on the table today. Thank you.
Thank you. Commissioner Gonzalez, did you have another follow-up?
Just basically, I just wanted to make sure then, any decision we make tonight, if we make a decision tonight, would it engage the city into any kind of a legal format or anything else if we did anything differently?
Chair, members of the commission, your decision today will be a recommendation to the city council, just making a recommendation either to recommending approval or denial of this proposed text amendment doesn't have any legal implications for the city, just based on what would be going up as your recommendation. I think what the speaker, as Mr. Curtis was indicating, is if you are trying to make a recommendation that the speaker would want, so a recommendation would be deny this unless there are a whole bunch of other changes to the ordinance that would favor their position. That would be difficult to do because those other changes, such as allowing them in allowing sober homes or care homes in multifamily districts, didn't go out to the public. They weren't notified of that, and so while the sober home community, the providers, may have gone to these hearings, the public wasn't notified that there may be a possibility or recommendation of the council to open up the ordinance to other districts. And so that would be quite shocking, I think, to the public to have a recommendation like that go up because they weren't notified and didn't have the opportunity to participate and make comments on a potential that a recommendation would be going up to deny this and open up the zoning ordinance to other things. So that, I mean, while that's not really before you, but that's kind of what the position is, I think, of the speaker.
Thank you. Thank you, sir.
Commissioner Ertel.
Thank you, Chair. Going back to what Commissioner Serena asked about of Mr. Curtis, if I understood correctly, Mr. Curtis, we have a map, and the map shows at least 3 different statuses of homes, care homes. Is the map, is there a legend on the map? Are the symbols such that this one is requesting a permit and this one is licensed and so forth and so on?
Yeah, Chair Higgs and Commissioner Tell, yeah, the map is primarily to serve the industry. When they're looking for locations, they could see the map and they could say, oh, I see the buffer, I could see an existing locked-in location and its buffer, so I'll look in the block where that's outside of the buffer. That's what that map is for, but it is publicly accessible, so anybody can take a look at it. And again, from a zoning standpoint, we don't indicate the disability, and we prefer not even to know what the disability is. If somebody has disabled residents, because we don't have a health department, we leave that up to the licensing of the state. They're just looking for either confirmation that they could do 6 or fewer, which is pretty rare, but it happens. But more often than not, they're looking for allowances to do more than 6. And then we get into, okay, so you're going to get a license from the state? Yeah. Okay. And then we look at the location, you meet the buffers. All right, we'll lock you in for 6 months. And you need to get a license within 6 months. And if you don't, then we need to talk. Do you need an extension? And so forth. So that's the purpose of that. But also there are color indicators on the map that indicates the status. And we periodically update those based off of the status. But there are dozens of care homes which we have to go through periodically to see if they're still eligible, if they want an extension, if it was sold and it's bought by somebody who's not operating a care home. So there's a bit of a chore to that.
And I appreciate that, and I hate to ask you to do additional work, but I would think that maybe there could be a count And maybe it could be like that pipeline report that you developed a year ago or whatever on apartments, that you have different categories. These are, pending. These are, licensed. These are licensed, ready to go away or whatever. But, so that we could have some sort of a feel as to how many of these there are out there. So that's enough of the count. I'll leave it to you if you can do that or not. I listened to this and I have a flashback to a year ago, maybe 2 years ago, when the city decided that they would pass an anti-discrimination ordinance that, affected certain groups, but not all groups. Not all groups that, suffered discrimination. And I don't know that there's any discrimination here. But I accent on the I don't know. Like Commissioner Serena said, there's a lot to this. And, I typically pride myself on coming in and being prepared. A couple of days ago, I thought I was prepared, but clearly, having heard this, having read some other stuff, I'm not. And I don't know what the protocol on this is. I would like to see, and this is just me talking off the top of my head, I would like to see that our legal staff and, the representatives, I don't know if the right word is negotiate, but, back in the day when I would have loan workouts, both sides would get, or all sides would get together and you'd work out something that worked. And given the city's support of anti-discrimination of those who are marginalized, if you will, I would think the city would be very interested in that. And it might mean, hey, going back to, having public hearings and so forth. And that's more work too. That's a lot more work than what I'm asking for on the map. But I do think it's important. And again, perhaps if I knew more, I would say, nah, we're totally legit. We are doing absolutely nothing wrong. We are accommodating, not just within the law, but within ethics, within community morality. I don't know, but I've heard enough questions about that I'd want to hear, I'd want to have another go-around at this, such that people wouldn't, nobody's going to be totally satisfied. But at least I'd like to be assured that we've come as close as we could.
Thank you. I have a question for Mr. Curtis. I know we state in the meeting notice and agenda, as well as on these blue cards, requests to speak cards must be submitted to city staff before public testimony begins. As Ms. Heather Dukes was speaking, we did have a late entry for a request to speak. Are we at the liberty to allow this person to speak, or?
Yeah, Chair Higgs, that's at your discretion. Thank you.
Okay. I'm sorry? Okay. Mr. Joseph Landon, would you like to speak? As a reminder, you have 3 minutes, and if you could please first state your name and address. Thank you.
Chair, Vice Chair, Commissioners of the Board, my name is Joseph Landon. Appreciate you taking the time to listen. I don't think I can get it all in 3 minutes, but I will go through a couple of my notes. Access to care has been completely eliminated in the city of Scottsdale. If you do a simple search and trying to find sober livings, it basically doesn't exist. There's 240 licensed sober livings in the state of Arizona at this moment that are above board, that are in compliance, that are going, and I hold several of those licenses. And it's repeatedly been told in the city of Scottsdale, I cannot open. MAP is a great example. Curtis gave an example that a lot of the homes on the map do not exist. So we're competing with businesses that do not exist. Those applications are old, those places have closed, and we're constantly told that the one-stop shop, you're in 1,200 feet of another home, you cannot do that. I've been told by building code you cannot open. I have requested reasonable accommodation. I am open today. Everything that I tried, I was told I could not open. If you look at this text amendment, several of those things are a direct response to what is in litigate, what is with the DOJ right now in a complaint. Those complaints are being addressed in this care home amendment, maybe in an attempt to save certain areas, but those amendments directly affect what my complaints are for with the DOJ. I spent 3.5 years in a sober living facility. I had 13 years of sobriety. It was a staple. It was the most important part of my recovery, more important than the institutions, than the treatment center's recovery process. It's where I learned how to live. It's where I learned how to, get a job, become a man, become, a stable person in society where, I've got to start a family. I have my 3 kids. I have my wife. We represent multiple businesses throughout the state of Arizona. I do feel the entire, ordinance needs a revamp. There's experts on this issue, which I've hired several of them throughout this process, because this is far above our head. It's far above my head, understanding the laws. I do know that I was discriminated against and that I was put against every single avenue that you cannot and will not open in Scottsdale throughout my process. I do like to hear the fact that they're not going to space on the less than 6. That creates a huge avenue for us to go open in gated communities. Currently in the city of Phoenix, I spent a whole entire year working in the group home ordinance, group home working committee. I spent a year working with all the consultants, the city of Phoenix, the attorneys. I'm familiar with the laws, and the city of Phoenix has been very favorable to us and protecting, Americans with disabilities. Currently in Phoenix, there's a community with 62 licensed behavioral health residential facilities. I think that should be looked at. I think that there's a lot to learn from the city of Phoenix. The city of Phoenix sends me a letter on a yearly basis to verify that I'm still in operation. Kim Stedman is their zoning and planner. I have his cell phone number. I can call him. It's a simple process. Kim, can I open or not? And he'll send me letters every year saying, hey, can you verify you still have a current license? I need to remove you from the map. That's not been taking place. Who knows for how long, how many pins still exist on that map. I'm out of time. I appreciate you guys taking the time to listen. I do know this is a large issue that should be looked at as a whole to protect, everyone involved, the city, avoiding litigation, as well as, the people with disabilities like myself. So thank you.
Thank you, Mr. Landon. Oh, do we have a question for Mr. Landon? Would you mind, Commissioner Kaminsky?
Thank you.
Hi.
I was just curious, in your experience, if this were to be passed, what would prevent us from coming back and having those dialogues to make further refinements down the road? So if this is a first step, for instance, the differentiation of under 6 opens up doors that weren't previously there, and it does have a reference to Title 36, which is very clearly tied to statutory regulations that we're trying to meet. What would prevent you from working with staff in, providing feedback to make those additional changes?
We'd love a seat at the table, and the city of Phoenix invited us in, and we spent a year on the group home working committee, and it involved outside consultants to make sure that the city was in line with fair housing, to protect, all those involved. So we're more than open to working with the city and getting a seat at the table. I think that we've all put in our efforts and tried, and I'm not sure if it's committees, willing to be created. We're more than willing.
Thank you again, Mr. Landon. Would the staff like to respond to any of the public comments? I know we've had healthy discussion thus far, but any additional comments or responses? No? Okay.
I have a question.
No.
If I had a condo complex with 25 units, I kept everyone in each one of those units under 5, would I be allowed to license each one of those with DHS? Or DHS will group those all together with unit numbers. So it's not a care home, it's an individual unit, because you could put families in each one of those units. So my question is, do I not fall under zoning because there's not more than 6?
So we don't provide legal advice to outside individuals. So that question is legally oriented. You'd have to get that advice from his own counsel.
Thank you.
Chair,
Yes, who said that?
what would happen if
Mr.
I would ask that question? Would you be able to answer it?
We might be able to answer that
I'll just point out, without answering his specific question, because a lot of them are fact-intensive, that the case that's been referred to the Board of Adjustment, that did involve a 10 condominium unit that the operator was going to place in there. And the result of that was that the board, through a stipulation ultimately from the zoning administrator, that would be treated as separate families, because as long as each condominium unit, it was a separate unit, and therefore if these separate families. So in that situation, that was the case. And as discussed earlier tonight, some of the amendments here are to bring the zoning more so it's clearer from that result of that hearing that the code is consistent with that.
So then going, I guess, kind of blending what Commissioner Kaminsky had asked, about, is 7 too many for a single 3-bedroom condo? If I had a 25-unit condo and I kept the occupancy of each condo to 6 or fewer, then I would be consistent with what you had, Mr. Anderson had referred to in the case that had.
If they're otherwise consistent with the
Yes.
family, the family definition that's in the zoning code. I don't want to give specifics, like I said, because sometimes there's facts, there's some additional facts and stuff that shouldn't be discussed here as far as his particular situation. But the intent of the amendments is to make it more clear that if you have a group of individuals that otherwise meets the city's definition of family as set forth in the code, they would be treated the same as any other family, with the eye of that's to avoid any discriminatory based on disability. So.
Okay, thank you. I am debating over asking this question. Anybody out there, feel free to cut me off if it's inappropriate. But, I've not heard any resident complain about, well, I don't want to have a sober house next to me because of issues. I've not heard anybody say that, but, I can imagine that some people might. And you have experience, and I don't mean to put you on the spot, hey, I have my VA disability as well, so it's, different, but still I understand. If you had your house next to me, or if you lived next to me, and there was an issue, what would you suggest that I do?
So each ethical provider has a grievance process where you can be submitted to this, individual house, or also through the state of Arizona. A complaint can be filed against us so long as you're a licensed provider, which we are. I do want to reassure you that we do operate as a family unit. I don't think we should be in line with the city's definition of a family, but the federal definition of alcoholics coming together as a family to share a common bond and have the same goals, which cooking, eating, we're all on the same mission together.
Right. So, but you would suggest that I would, hypothetically, file a complaint with the government as opposed to just coming over and talking to you?
I would love for you to just come over and talk, because the issue can be addressed a lot quicker. And I hate dealing with DHS, if they did show up for a complaint, because most of the time it's, someone that's being malicious, or it's an old client that's, upset. I'm aware of the recent issue in Scottsdale with probably an unregulated sober living home. I'm not sure if it was licensed, but we would appreciate, we're usually the best neighbors. We'll help you move some furniture around. We'll, keep our yards clean, because everyone has chores in the house. We do our best. For parking, we do have to have approved parking spots through the state of Arizona. The state's already highly regulated us in many different areas to keep us in compliance. And that's for the 240 ethical providers in the state of Arizona. As we know, there's probably thousands of unlicensed, and creating more and more stipulations through city zoning, and text amendments like this make more and more fly under the radar, and most of the time you would never even know they were next door.
Okay, all right, thank you very much.
Thank you.
Okay, we have had a very healthy conversation here, and I appreciate everybody's feedback and contributions to this topic. Thank you so much. This agenda item, I should clarify. Some of us may have more questions than answers at this point, but I would still like to ask if there aren't any additional questions or comments. Is there a motion anybody would like to make?
I'll make a motion. I'll make a motion to move for continuance of case 1 TA 2022 to a further date.
I second.
Okay, we have a motion from Commissioner Serena and a second from Commissioner Ertel. Can we please get a roll call vote?
Chair Higgs,
Yes.
Vice Chair Young,
No.
Commissioner Gonzalez,
No.
Commissioner Kaminsky,
No.
Commissioner Ertel,
Yes.
Commissioner Scarborough,
Yes.
Commissioner Serena.
Yes.
Motion carries 4-3. Thank you.
Thank you, everyone. With that, we will move on to agenda item number 3, 1 TA 2023 IQCC Implementation Text Amendment, Phase 1. Mr. Carr.
Thank you, and good evening, Chair Higgs, members of the commission. Brad Carr with the city's planning department. As you mentioned, I will be giving you a presentation on staff presentation on the city-sponsored text amendment for the IGCC implementation. So a little bit of background on this text amendment starts back with the city's initiative to include the IGCC as a mandatory requirement as part of commercial and multifamily developments moving forward in July. So back in December of 2022, last year, City Council passed a family of building codes, a 2021 family set of building codes, which included the IGCC, that International Green Construction Code. That amendment and adopting of those codes at that time put forth that mandate to have multifamily developments and commercial developments moving forward from July on to have the IGCC as a requirement. As a result, City Council has initiated an update to the zoning ordinance to address any of those conflicts that may exist within the zoning ordinance and that new IGCC mandate. There are a number of spots within the zoning ordinance that reference green building and green building mandates, and we'll go over those here shortly. So a quick text amendment to address those is required. That was initiated back in January of 2023, this year. Just for some background on what the International Green Construction Code is, it's part of the overall family of building codes developed through the US-based International Code Council. The IGCC provides requirements for sustainable commercial and multifamily buildings, including renewable energy, water efficiency, indoor environmental quality, reduced construction waste, and amongst a few others. The City of Scottsdale has specific amendments to that version, the 2021 version of the IGCC, to enhance and the use and flexibility of that code. Some of those amendments clarify the requirements for photovoltaic panels, solar panels, what we would like to have addressed with heat island, construction waste, irrigation efficiency, EV charging, and others. So going into what the zoning ordinance updates are proposing to do, again, very minor in overall scope, but a few very specific areas. The definitions within the Scottsdale Green Building Program definition, there's some revisions to the objectives there to align with the IGCC better. Plan Regional Center Code or zoning district. Currently within that, the Green Building Program, which is essentially the IGCC requirements. To achieve bonuses within the Plan Regional Center, you have to adhere to the Green Building Program. Because that requirement will become mandatory in July for all projects, regardless of what they're trying to do with the zoning, we are going to basically strike that requirement from the bonus requirements. Plan unit development, zoning district, a small change there to change a reference from green building to sustainability, again, to align with the IGCC update. Within the environmentally sensitive lands ordinance, currently, as probably many of you know, very strict requirements for light reflective value and reflective building materials up in our northern part of the city. Again, to allow for solar panels and other reflective building materials on roofing areas of buildings. We are going to make an exception to bring that into conformance with the IGCC requirements for additional solar panels and reflective building materials on roofs in that area. Finally, within the planned block development, similar to the planned regional center, there is a requirement to adhere to the IGCC. Currently, if you are seeking to achieve that planned block development, again, because that's a mandatory requirement moving forward in July, we're looking to strike that requirement from the planned block development. So as a matter of timeline, again, council initiated this back in January. We did have a draft of this proposal prepared through February and March. We did our public outreach just recently in early April, and we are in front of you here tonight. Where City Council has proposed to look at this June 13th, so a little over a month and a half from now. And we will be looking at Phase 2 updates to, again, piggyback on some of the ideas that IGCC has to further enhance our zoning code to align with those. There's no date on that. It's kind of in the future. But those will address, again, more zoning ordinance definitions, terms, and requirements to further have further consistency with the IGCC. So that concludes my presentation for this evening. Again, the recommendation to Planning Commission to City Council is what is requested this evening. I'm happy to answer any questions you may have.
Thank you, Mr. Carr. I'll start it off. The public outreach was in April. This is April still. What type of outreach was that, and what kind of feedback has been received?
Certainly, Chair Higgs. Those typically occur as 2 open house meetings, one in our northern part of the city and one towards the southern part of the city. In attendance was only 5 residents. 3 of those were council members. And so, again, the attendance was low, which is somewhat typical of text amendments. And the feedback was, looks like it's a good change. We're trying to align our goals and policies of the IGCC with the zoning ordinance. So that was basically it.
Thank you.
Yep.
Commissioner Ertel?
The city, and rightfully so, has made an issue of maintaining the character of neighborhoods and regions and so forth. And for years, those of us in the ESL and on HOAs have insisted homeowners keep their paint within the 40 or 35 LRV, depending on where your house was built, limit. And now we're saying let's get rid of that for the low sloping, or the whatever it's called, the slightly sloping roofs. It's going to change the character of the neighborhood. If you go to, I believe, I've asked other people that know more about the architectural side of things than I do, doesn't color contribute a lot to defining a neighborhood? And well, that along with landscaping and materials and so forth, but still, color is key. And to hike the LRV, what does it go to, 60, 85, something like that, whatever it is, from 35, that just seems to be pretty drastic. I understand the city wants to go to IGCC requirements for building, but do you just blanket the entire city, including the ESL sections, with that drastic change in color? Has that been a topic of conversation with among staff and with council and so forth?
Absolutely. Chair Higgs, Commissioner Ertel, we do, as a matter of practice, have been for a while, allowing some flexibility in roof applications. So these are usually flat roofs, as they classify as low slope roofs, that have some kind of foam roofing or built-up roofing type of application that usually from manufacturer is white color or off-white color to begin with. And so generally those are applied industry-wide regardless of where they're at, whether it be ESL or in the southern part of the city. So we've already been seeing a lot of buildings with flat roofs and ESL have this. Technically they've been out of conformance, but our feedback from the community, we haven't really seen people complaining that these low slope roofs with white or off-white colors have been blinding them or affecting them negatively. I think if you're on a vista and you have a view down on some properties that are below you, they might have that flat roof. Maybe you're getting a little bit of that view of that white from those roofs. But generally people on the ground level, you're not seeing that white at all, and we're not changing the paint color on building sides. The LRV is still going to be maintained with that 35 or 40, depending on, as you mentioned, where you're at in the northern part of the city. So that portion is maintained. With regard to solar panels. Generally, solar panels have a coating on them that is meant to absorb as much light as possible, but there are components that could be reflective. So we want to, again, promote that sustainability component with the allowance of solar panels. There's an inherent conflict with some of that language in the code that says you can't have reflective building materials. So exempting solar panels helps allow those to be applied to buildings with that sustainability idea in mind.
Right, and I understand the solar panels, and yes, that makes sense, and that seems like a reasonable accommodation for that. And certainly flat roofs, yeah, they can all be white as far as I'm concerned. You do make a good point if you're in a building taller and you look down on that, but I guess if you're in a building taller than that, you should be looking at the landscape, the horizon, and not down on the roof next door. I guess there are times when you would want to look down, but that's different. Still, I can see the solar panels, I can see the flat roofs. I'm just having trouble with having the low slope roofing material be that bright.
And perhaps, Commissioner Ertel, I should have clarified a little bit what low slope means as far as the building code. It's generally slopes that are of, I think it's 2 to 12, 2 over 12 or less. And so those are generally just flat roofs. So anything with a pitch on it is generally 3 or greater to 12 or more, and those wouldn't be classified as a low slope. So those aren't going to be exempted with this. It's generally just all the flat roofs that we're looking to address, where industry usually applies that white coating as a matter of course, and we've been doing that for a while.
Could you give me an example? This will be my last question. Can you give me an example of one of those 2 to 12 slopes that, is there a building around that you could just mention and I would recognize that has that low slope?
I don't know if I could mention one, but generally if you look at like a mid-century modern building, even those have something of a 3 to 12 at least, so those wouldn't be exempted. It's really just generally flat roofs with a parapet is those type of roofs that you're going to see are flat, generally speaking.
Our city planner down here agrees, so I guess I've got my answer. Thank you very much.
Yeah, even the city offices across the street would be an example of something like that.
Okay. Well, that's visible, isn't it?
The roof? It's
Yeah,
2 stories.
the low slope roof. You're saying those are in the low slope category?
Yeah,
Okay.
that's correct. But you can't see it because it's 2 stories.
This building we're in is a low slope roof. It's flat.
Okay.
essentially.
All right.
Yeah.
Thank you.
Commissioner Kaminsky?
I was just going to add that after one storm, it's all going to be desert brown anyway.
Yeah, that's the practical reality, I guess, is most of those roofs start out white, but they end up being tan.
Well, then why didn't you say that to begin with?
Yeah, right.
I'm going to begin calling on people in different orders. Any other question? Commissioner Gonzalez?
Well, I've been looking at this suggestion by this association. The IGCC is an immense association. I mean, if you look at their code book, I'm sure you have, I have. I'm familiar with it. I've gone to a couple of the building advisory meetings on it and things like that. It's a very far-reaching code or set of codes. It's very far-reaching. And it interprets the whole United States. And we know that architecturally, we are not part of the rest of the United States as far as some of our designs are. It gets to the point of, everybody, most general people, when they look at this that, are not in the business or not architects or not planners, they really don't understand the code because it's so complex. It's so vast. It's actually even hard to even discern it to people sometimes because it goes from electrical into building into, it's fathomless as far as the explanations go. It takes a lot of time to look at it. That's why it's been out for about 1.5 years, and they always do revisions every 2 years anyway. So the biggest problem for me is because it's so far-reaching, it doesn't really cover everything in that it covers the Southwest specifically. It goes through the whole country. And it approaches a lot of different things as far as electrical and a lot of demands for developers and builders and things of that. Our construction businesses in this state will be impacted by this by quite a bit. There's a lot of specific items that people have to build in and price in to their commercial projects. And it's not a cheap fix. It's not a cheap fix, and frankly, you know, even the retro remodeling, it'll affect that also. When somebody comes in for permits, new demos and things of that nature, the business people are gonna really be affected by it. You know, the pitches that you were talking about, like on the roof, it doesn't go just because you can see the pitch or you can't see the pitch, but it also says there has to be certain levels of this pitch in certain aspects and how it'll cover other aspects and how it looks across the board to like a gable or something of that nature. It comes into parts of architecture that are not really a mainstay for this area. So we're going to take this code and implant it onto the people here in the Southwest. And it's not, it's like taking different shoe sizes and say everybody's going to wear a size 10 and that's it. You know, if it fits you, fine. If it doesn't, too bad. This is what you have to live with. And so it's going to impact the industry quite a bit. In fact, if you talk to some of the industry people, a lot of them are not that crazy about it, but they see, you know, everybody wants the green aspect of it is very popular. It's a very popular thing to have. It's a very popular thought to have, but it just will have such an impact on our business that I think that I wouldn't particularly go along with it because I've seen parts of the code that I didn't particularly agree with, and you know, I don't want to waste your time in going over this now, but I'm just saying as far as an impact, that is some of the things that I really don't like on the overall code itself. So that's kind of what I was going to go into, and that's my explanation.
And just a second. I'm just following on to Commissioner Gonzalez real quick. I mean, you do make a good point that one size does not fit all, back to the shoe size example, right? However, I mean, green building practices are a big thing in Seattle 20 years ago when I marketed them and solar panels and whatnot. And speaking of dust after a dust storm on the top of the roof, they all have moss growing on the top of their roofs. So there's different unique challenges with every part of every geography within the country, right? I assume there were certain considerations taken given the variation of Southwest versus everything else that was kind of just spread across in IGCC, or can you touch on that?
Absolutely, Chair Higgs and Commissioner Gonzalez. Yeah, certainly any new code that comes in, there's going to be some growing pains, and I think our commendable staff, certainly our expert on staff, Anthony Floyd, who, if you don't know, he's one of the person that actually works with the International Code Council and was really integral with the IGCC to begin with. But he worked for quite a few months alongside Michael Clack, our Chief Development Officer, to try to adapt, so to speak, this IGCC to the Scottsdale area and the desert region as a whole. And so they went through and made a number of amendments, as I mentioned. Most of the code as brought over from the IGCC wasn't brought over in its entirety and its word for word. There was a lot of amendments made in order to adapt it to those things, those considerations, as Mr. Gonzalez brought up. And so I think through their efforts, we have a code that's hopefully can be implemented and will be embraced by the community. Scottsdale's always thought of themselves as a leader in a lot of regards to the building community. And so this is another step in that direction. But again, I think the efforts that my colleagues made with trying to adapt that code to meet the needs of this community should make it very successful.
Thank you, Mr. Carr. Commissioner Scarborough.
Thank you. I just make a point of order here is that the IGC is not on the table for discussion. It's already a thing. What we're talking about is text amendment, very specifically identified by Mr. Carr. So I just want to make sure we can sort of stay on track and just focus on the text amendment that's before us, not the IGC in totality. Thank you.
Well, that's why I thought it was helpful for Mr. Carr to kind of expand our portion of that. Commissioner Kaminsky.
Yes, I just wanted to clarify that this was applicable to multifamily, commercial, industrial, but not single family, is that right?
That is correct, yes.
And is it only for new construction, or the comment earlier about impacting renovations? Is there a threshold that would then trigger some additional requirements?
You know, I'm not 100% sure about that component, Commissioner Kaminsky. I know Michael Clack, our Chief Development Officer, is working on what that threshold may be. Certainly all new construction will be applicable starting July 1st, but there may be a threshold that says, you know, if you're not affecting, I'm going to choose an arbitrary number, 50% or less of your building, maybe you're not, you don't have to do this. I'm not sure.
Okay.
But I'm sure that's going to be worked out over the next few months as we get closer to that date.
I know we're not talking about content, but I'm sure they removed the Alpen roof line requirement, so. Thank you.
Chair Higgs and
Yes.
Commissioner Kaminsky, if I could just add to that, your question, I think, was about where is IGCC applicable? Is that correct? Because this text amendment is a zoning code
right.
text amendment.
Yes.
So the changes to the ESL provision, for instance, in terms of the solar panels and so forth, that would apply to single family in order to allow them to opt into the IGC, which isn't required.
But it's an opt-in in that case.
Correct.
Yep. Thank you.
Thank you for that clarification. Would anyone like to, I think we've exhausted this one pretty well too. Anyone like to make a motion? Commissioner Kaminsky.
Yes, I would like to move approval of agenda item number 3-1TA2023, the IGCC implementation text amendment phase 1. Move to make a recommendation to City Council to approve this after determining that the proposed text amendment is consistent and conforms with the adopted general plan.
We have a motion from Commissioner Kaminsky and a second.
Second.
I'm going to go with, okay. Commissioner Ertel. Can we get a roll call vote, please?
Chair Higgs,
Yes.
Vice Chair Young,
Yes.
Commissioner Gonzalez,
No.
Commissioner Kaminsky,
Yes.
Commissioner Ertel,
Yes.
Commissioner Scarborough,
Yes.
Commissioner Serena.
Yes.
Motion carries 6-1. Thank you.
Thank you. And last but not least, we have Mr. Murillo to discuss our non-action item this evening, ESL discussion.
Good evening, Chair Higgs and members of the Planning Commission. Thank you for having me here tonight. Yes, today I'm hoping to provide a little bit of discussion and a little bit of history for a text amendment request that staff will be bringing before the Planning Commission at the May 10th hearing. And as some of you know, and many of you are probably have heard through other cases that you've seen, the ESL ordinance can be a little complicated, and so we will be coming to the commission requesting to be able to amend some of that language. I'll discuss a little bit about what we're looking to update that, but we thought it'd be a good idea to come before you and provide a little bit of history and kind of how we got to this point, and hopefully make the discussion on the 10th a little easier. So thank you for having me. So first of all, in 1979, the city adopted what was known as the Hillside Ordinance, also known as HD. And so this ordinance was really incredible. What it did is it looked at the city as a whole, and it said, how can we have development work with the environment? And so the city, from all the information that I read, was really excited about it. And it was a lot of the residents came through and had support from them, and so it was put together and it was put into practice for a while. And then in the late 80s, there was an element about it that was questioned it was challenged. And there were some elements, first of all, of the Hillside Ordinance that kind of you'll see as a thread throughout each one of these versions. And the first thing that the Hillside Ordinance did was it established natural area open space. So in essence, what that is a certain percentage of the property is to be left undisturbed. Now, there's caveats to that, right? A certain percentage of it can be disturbed as long as it's revegetated back to a natural state. And there was also some limitations on where this development happened. Now, again, as a first ordinance, there were some elements from when I read the reports and I read the original transcripts from the hearings, some of the development community also appreciate it, but there was an element about it that was questioned by one of the developments coming through. And so that, when it went to final decision, it was looked at that there were certain elements that could be refined. And so in 1991, the city adopted what was going to be known from then on out, the Environmentally Sensitive Lands Ordinance. And so that kept a lot of the components that the original Hillside Ordinance did. One of the different changes was that in the Hillside Ordinance, there was no certain width for natural area open space. It was just kind of whatever width needed to be designed around the property. And one of the changes that was made from that, or from the Hillside to the ESL, was that the minimum width for NAOS now had to be 30 feet. Also in the Hillside District, there was not any requirement for the size of natural area open space that had to be contiguous. And so in the 91 ordinance, it was written into the language that NAOS couldn't be anything smaller than a 4,000 square foot contiguous piece. And so the ordinance, as we'll see it today in the green, was kind of taking shape there. And it seemed to have support from the community. And again, there was, as you read it, there's comments on both sides, but at least it was seen as a much cleaner version of the Hillside District. Along with one of the things that kept in common between the 1979, 1991, and as I go into the 2001, is that the height for structures was based off of whatever the underlying zoning was. And so a lot of those things, what portion of the property should not be disturbed, and if disturbed, revegetated, and what bridges, hillsides were protected, those were always a common language. And it was in 2001, there were very small changes that were made, and it was mainly looking towards adding certain language about certain features. For example, the Hillside District focused just on that, hillsides. And then once you got into the 91 and 2001 ordinances, you saw that washes were being included into what was considered environmentally sensitive lands. And then in 2002, a lot of that language continued from the other versions, except at this point in time, it was deemed that perhaps the underlying zoning would be too high for a residential structure. And so in 2002, the ordinance was amended to limit the maximum height to be 26 feet from natural grade. And really that was the biggest difference between those ordinances and the previous ones. And then when you get to 2004, at that point in time, the ordinance has been looked at, and most of like I said, most of those similar threads like natural area open space, protection of washes, protection of ridges, those became a common language. And in 2004, some of the main changes that occurred was that now the ultimate height was lowered to 24 feet for residential zoning districts located within the environmentally sensitive lands. And there was also a decision that walls located within the rear or side property line should always maintain a minimum 15-foot setback from a rear or side property line to always have a corridor area for either natural drainage ways, excess drainage ways, or for critters and natural habitat. And so it is that 2004 ESL language that staff will be looking to amend. So what some of the elements that we will be looking at are kind of identified on the slide. I do want to state that staff has spoken with a lot of developers in the past since the inception of 2004, and staff has spoken with a lot of residents. Since then, we've grown up. I'll say I grew up with ESL. That's about the time I got hired with the city. So we've grown up. We feel we've found since then where it provides some hardships for properties that weren't necessarily potentially deemed to be under certain regulations. And so although The elements that you see on the screen and what we've heard from the residents are all things that we will want to look at during the text amendment. It is really, the text amendment will be fine-tuned, at least for this first phase of it, to look at those properties that from either annexation or from development prior to the 91 version of ESL, the 2004 version of ESL being placed over the property, can't meet some of those requirements. And so staff will be trying to focus on that, but we do want the commission to know that we will entertain all thoughts, all conversations, and hopefully this will turn out into phases. But we wanted to touch the most pressing elements that we've seen as we work the front counter and as we review developments for single-family homes in the north. So as part of this, staff will not do too much to change or any other language that might affect the native plant ordinance, the natural area open space ordinance as it reads today, and scenic and vista corridors. Those are established through several other elements, including the general plan. But there are some of these other elements that you see here that we will probably touch on. But again, depending on the support for the community from the commission and from the development community, some of those might be put off to the side as the main discussion is moved forward with. Just so you could become familiar, these are some of the maps that were aligned with each of the versions of the zoning ordinance in regards to ESL. This map that you see here, the larger one, that's the one that was previously discussed in Mr. Carr's presentation. That's the one that does have a discussion about the color value, and also depends on where you are in the city. Some of those things we would like, we're considering also maybe unifying and just having one number. There are places in the city where, one house literally next to another can have an LRV that's different than the other based off of the map. And so trying to find some of that consistency will also be part of staff's goal. So tonight, there's not going to be any action requested from the commission, but on May 10th, staff will be recommending that the commission initiate an ESL text amendment so that we could start looking at some of these elements. For example, the first one being impacts on existing developmental properties as it relates to nonconformities. And that's the understanding in the application of which one of those versions of ESL apply to you and how, and are there inconsistencies that maybe could be had without compromising the other versions of it. We're also going to look for conflicts and clarifications. Those are for some of the properties that exist within the environmentally sensitive lands. When they first developed, they might have been allowed the 30-foot discussion on a structure as we discussed with the HD, but because they're considered meets and bounds, the latest version of ESL would apply to them. And so in this instance, if they came in to do an addition, the current ordinance might say, hey, your addition might be limited to 24 feet. There's some examples like that that we want to make sure that we make consistent for some of these homeowners. The other one is prohibiting non-conforming homes in EXL to expand. If I may give you a brief description of what that means. Currently, the ordinance for non-ESL states that and I'm oversimplifying, please understand that. But in essence, what it says is that and every case is different, but usually the rule of thumb is as long as you're not increasing the nonconformity, and there's research that's done whether it was permitted or to not what extent would it have met the ordinance back then. So again, I'm oversimplifying, but you may develop a property that's nonconforming as long as you're not increasing the nonconformity. And if you choose to touch the nonconformity, there's a different discussion for that. And currently, the environmentally sensitive lands ordinance states that in order to develop a property, all nonconformities must be addressed. And so that's obviously when you're on the front counter or you're having a discussion with the resident. Some of these discussions aren't the easiest to deliver, especially when it appears as though, from their side that, the project has been passed on from one person to another. And so one of the elements that staff will be looking for, and really is kind of the focus on, are these non-conforming properties and how they can or can't develop within ESL. And our goal is to align that a little more with the thought that is had within the non-ESL as far as the nonconformity exists. And again, it can get very complex real quick, but at least we're going to attempt to see if we can have that conversation.
Chair Higgs, if I could just add a couple points to the presentation. You saw that timeline, 1991 and so forth. And obviously the objective of the community was to try to protect the environmentally sensitive lands, right? But within that time, I'll just remind you that the city went above and beyond that, and the taxpayers, by purchasing so much of those lands for the preserve. So a lot of the concerns that we have with the ridges and peaks and steep slopes have been pretty well resolved, not with this regulatory document, but with the purchase of so many acres in the preserve. So that's been something that we recently done relatively to that timeline. So it's a great opportunity to take a look at seeing what's in this code and what still is applicable or not based off of what has happened over the years. But the other thing, and Mr. Murdo was too polite, I need to say that in terms of the frustration of homeowners, it's very extreme when they don't fit into the environmentally sensitive lands box in terms of how they can modify their homes if they're non-conforming. You just can't do it, and it's extremely frustrating. And to put it bluntly, there's a lot of staff man hours, trying to look for compromises and solutions with these homeowners while working with the ESL ordinance to allow them to reinvest in their properties. And it's really been challenging. And if there was a way that we could gather all the different homeowners that we've been working with for their simple additions and modifications over the years to bring them down and express that, but we can express it because we deal with it, a lot of man hours on that, a lot of frustrated homeowners. So we're trying to identify where those frustrations were that have proven to be low value, results, and try to see if we can tweak that to make it easier on everybody without compromising the objectives of ESL, and that's really important. And one of those, and he touched on, was the light reflective values. Some people have 35, some people have 40, and nobody can grasp that. Am I 40? Am I 35? We spend hours doing research to see which one you fall into. My neighbor has 35. Why am I at 40, or vice versa? And that's been, a challenge, and there's debate whether that's been worth fighting over 5 points on that. So those are some of the things that we want to share with you and the rest of the community to see where the value is. But we're really trying to help out the homeowners, which then helps out the planners at the counter trying to issue permits and let them reinvest in their property. So I can't emphasize that enough. Thank you.
Thank you so much for that background and additional information. And mentioning also the purchase of additional lands by the city over the years. That must have been during that time frame, the last 19, because the timeline was like every few years and then nothing after that. What other changes were made that may be worthwhile knowing that we may have missed?
So Chair Higgs, pretty much in the 2004 version of the environmentally sensitive land has pretty much been intact since 2004. There haven't been any amendments.
No amendments at all.
There have been 2 small interpretations that staff will present to the commission when we give a more complete presentation, but it's pretty much been intact since then. And as Mr. Curtis alluded to, there is a lot of frustration, and I figured that depending on how many people feel in here, you'd start to grasp that pretty quick, because we hear that on a daily basis at the front counter. And so as part of that, staff thought, we're seeing it more at the front counter. They're expressing frustrations, and the environmentally sensitive lands, as the Hillside Ordinance, have all been grassroots ordinances. And the same thing today. We are standing in front of you because we are hearing the frustration of residents. They want the conversations to be had in public, and they would like to be able to see the ordinance, because right now, really the ordinance is what we point to when we respond on development.
Gotcha. Yeah, thank you. That's helpful. Oh, Commissioner Scarborough.
Thank you, Mr. Maria, for bringing this forward to us and let us have an advanced look here. My questions are really more procedural. Can we go back to the slide for the timeline related to what we're doing here? Oh, do you have one as far as this text amendment is concerned? I'm curious what the process is going forward, the community outreach. Are we getting a first draft read, almost like a study session, or and then are we having an actionable session thereafter on this text amendment? So can you just walk me through from this point forward, what's the procedural process to get us to an end goal?
Yes, definitely. Chair Higgs and Commissioner Scarborough, staff didn't, especially because we're not requesting it tonight, staff didn't want to assume that you were going to initiate the text amendment next at the next hearing. So that's why we don't have that timeline for you. But the first thing that staff would do is, I'll say staff, but I know that I personally, throughout the discussions, both on the front counter and with projects, we've put together a little list of both community members and developers that have expressed concerns with the ordinance. And so even though they understood that the main focus was going to be for non-conforming properties, they thought this was a good opportunity to provide opinions. And again, we're willing to move forward anything that won't slow down the nonconformity part of it. So I wanted to say that first. And so we would have focus groups with those different teams, because we've been writing down their lists and their concerns, and so we want to hear the way they feel about those, because some of them, as you can imagine, someone can look at the same ordinance differently, right? Some think, hey, this isn't really protecting me the way I want it to, and some say, hey, this is a little burdensome to us to be able to achieve. And so we think that having that discussion with both in the room would be important. And so first we will, and these are people that have specifically told me through the last 3 or 4 years, 5 years, that they specifically, when I mentioned the ESL text amendment, that said, I would love to be part of that discussion. So I thought to start there. And then we will be having open houses for the community so that they can see the different, and we'll have a couple items there, again, always highlighting the nonconformity portions of it, and bring forth as many of those that we think we can move forward easily with support of the community, the commission, and the council. Once we do that, we are going to then attempt to make the actual comments to the text as possible. And there's 2 versions of that we'll be working on. The first version that we're working on, that staff has kind of worked with the attorneys on up to this point, is just having the language be consistent. Some of it is just going to be making sure that in some areas we say ESL, some places we say ESLO. So we're hoping that a piece of it might just be making sure that we're consistent with our language. That portion staff has been working on, but again, that's not changing any of the actual essence of the ordinance, just making sure that we're consistent with our language. Having said that, we will use those open houses and those specialty groups to come up with language, and that's when we'll come forth to the Planning Commission with the first version. We would expect that it potentially won't just come here for your vote and then on to council. We were expecting that we might be here once or twice because, at that point in time, when we advertise for a public hearing is a little different than going off of, the people that we know now and people that have a vested interest in it. So we would probably get some more information that night. And then once that language has been vetted through the Planning Commission, then the Planning Commission will decide when that moves on to the City Council for the final vote. And so right now, that's what we've got at least sketched up. Obviously, we don't want to assume anything, so hopefully next week's discussion will help give staff a little more direction, and will also allow for staff to share more concretely what our path is going to be.
Thank you. I really appreciate you explaining that.
Commissioner Ertel.
You mentioned, sir, and thank you for the presentation. You mentioned having parties that have a vested interest, and you said that a couple of minutes ago. And before that, I was thinking, all the people that are commenting are those people that have a problem with the text as it is now. And I'm thinking, what about the people that are happy? What about the people that, appreciate the restrictions that the ESL ordinance puts on development? And so I'm thinking, do you have any HOA people, officers, boards that are involved in this? Because, the people that live in that area, they have a vested interest in keeping it environmentally sensitive and not simply developer, accessible. So can you add people like that to the, to your considerations?
Yes, Chair Higgs and Commissioner Ertel. Forgive me, I should have elaborated more. When I say so far the specific or interested parties that have contacted me, some of those do, like I said, land on the side of things need to be clarified so that they feel that the language should be clarified to further protect ESL.
Okay.
We have members from the, so far written down, I have members from the Legend Trails community who have also shared their frustration with some of the language that they feel if it was clarified, it would help protect certain areas better. There's a couple people from the Friends of the Scenic Corridor that I've been in communication with for a while, and as you know, they're the ones that really look into the foothills overlay area and even portions of ESL as they relate to that. Some of the homeowners that we have are those that have seen neighbors do stuff to their property even though they've kept theirs. So we do have a little of everyone. Like I said, after about over 5 years, I haven't just collected one side, it's been the other. And that's why I know.
Always a step ahead of you, so thank you very much.
No, yeah, and that's why I thought it was going to be interesting because for the same ordinance, we do have two people who view it differently.
Good, okay, thank you.
Thank you.
Thank you.
Chair Higgs,
Yeah.
members of the commission, just if I could add,
Yeah.
As we embark this, as well as other text amendments, we may be looking at a wider scope, but realistically, we'll probably want to start with a smaller scope, the ones that low-hanging fruit, so to speak, that most, if not everybody, agrees on, and particularly the ones that frustrate homeowners and as well as staff, in order to continue allowing those reinvestment opportunities. Those are, that could be a first phase, smaller scope, as we look and hear from other people about other issues that may be more complex. So it'll be interesting to see how this rolls out. Thank you.
Thank you so much for that clarification, Mr. Curtis. I think we've exhausted this topic pretty well as well. Thank you. And we don't have to take a vote on this as it's a non-action item, so thank you so much for your time, Mr. Morello. And for the rest of the commissioners, do we have a motion for adjournment by any chance?
So moved.
Okay, motion from Vice Chair Young and a second from Commissioner Scarborough. All in favor?
Aye.
Motion passes. We're adjourned. Thank you. Good night.